states remain in place. Remain in place. And so here I'm referring to the current 27 bilateral investment treaties member state that European member states have concluded with China many years ago. So these 27 BITs are important because they do not disappear. They remain in place. And as long as the CAI does not enter into force, that may be until the end 2023 in the best scenario, these BITs remain in place and they regulate all the investments made by Chinese and European investors between themselves. So the EU and China have been negotiating the CAI since January 2016. In fact, when we look back at the negotiation, it's important to know that in July 2018, the EU and China dealt with market access offers during what was the 20th EU-China summit. Then you had some further negotiations. And the negotiations from May 2019 to December 2020, so until the milestone of the conclusion in principle of the treaty. So the negotiations from May 2019 to December 2020 were thought to have addressed a number of very important critical concerns, which included market access. And in fact, a negative list approach had been agreed upon by both parties at that time. National treatments, both parties have reached a consensus on which kind of enterprises shall be treated as Chinese investors and thus enjoy national treatment. And it's also at that time that the different positions on ISDS crystallized. And this is when the two parties understood that they could not agree on either a permanent court or a form of arbitration. So that was important as part of the process of negotiations because in some earlier treaties, the EU had been able to convince the partners about the benefits of having a permanent court. And that was the case, for instance, in the CETA, so the Canada Comprehensive Economic and Trade Agreement, and also the EU-Vietnam Free Trade Agreement, EVFTA. Both CETA and EVFTA feature a permanent court. And that's something that the EU has not been able to achieve with China. And that has a number of interesting implications. Under the existing ISDS mechanism, multinational corporations are allowed to sue governments before arbitration directly. So from the 1950s to now, EU member states, at the time when the EU didn't have the power, the competence to negotiate investment treaties like the CETA, EVFTA, or the CAI, so the EU member states had concluded more than 1,000 ISDS type agreements with other countries. So that's important because it shows you that a move from the current ad hoc arbitration system to an international investment court mechanism is a big change. And that's something that had been spearheaded by the EU. Now, another important element is, of course, to look at the economic relationship between EU and China. What I feel is important to highlight here is that international trade between the EU and China has developed rapidly in the past 40 years. In the mid-70s, the total trade volume of the two sides in a given year was not as good as that of today's 24 hours. So that gives an idea of the dramatic change in terms of economic relationship between the EU and China in just 40 years. Now, however, the investment relations between EU and China have not grown as quickly as trade. In fact, in 2015, the EU outbound investment in China was not more than 1/10 of its investment in the US. So although China and the EU have had some disputes over the trade of, say, steel, wine, and solar panels, they also reaped many benefits. So both China and the EU are basically seeking nowadays to protect their respective national investors within the other party and their own internal market from competing with investors from the prospective partners' territory. That bilateral relationship is also something that we need to put into the broader context of the world economy. And looking at that, what I think is important is that since roughly 2013, the world economy has continued to recover from the 2008 financial crisis. In this period of time, Chinese investments have become more valuable for the EU, also because of the euro crisis. And so here you have an interesting statement made by John Clancy, the then EU trade spokesman, who said that the current level of bilateral investment between the EU and China is way below what could be expected from two of the most important economic blocs on the planet. And the main purpose of these negotiations is the progressive abolition of restrictions on trade and foreign direct investments, and to improve access to the Chinese market for EU investors. So that's a statement which is very clear and very important, because it shows you that in the context of the bilateral negotiations or the bilateral relations between EU and China, investments is an aspect of the economic relationship that they know can be significantly improved. And that was, of course, the objective of the CAI negotiations. And that's against this objective that the CAI should be assessed, among a few other things. So with a comprehensive EU-China investment agreement, a simpler, a more secure and predictable legal framework can be provided to investors in the long term. And both the EU and China can be expected to gain several benefits. I also want to add, when thinking about the bilateral dynamics, that historically, China has not shown much interest in international dispute settlement mechanisms. And also, China is evolving from a mere foreign direct investment recipient to a two-way actor in the EU-China investment relationship. So China's positions on the CAI, but also on the question of dispute settlements, is something which is relatively flexible. In particular, the Chinese position on the ICS is not something definitive, and that's why they have some further negotiations. China, in fact, has never expressly opposed the proposed investment quote system. In fact, the ICS-related risk prevention has been a focus of China's Ministry of Commerce, the MOFCOM. So this can be viewed as something positive, although implicit signal to favor the reflection and negotiations of an ICS as a form of dispute resolution. So I've briefly discussed the historical development of the CHI and its broader context, what's in, what's out. Now, I'd like to zoom in, if I may say, and look at the details of what's in, and in particular, the substantive rules of the CHI. I'll try to answer a basic question, which is, what is the CHI made of? What do we find in this treaty, and what does it mean? So, in short here, what I'd like to stress is that fundamentally, the CHI is an attempt to rebalance trading power between the signatory state parties and their foreign investors. In fact, fundamentally, China is committed to ensuring a fairer treatment for EU investors to allow them to compete on better conditions in China. However, compared to other investment agreements, the CHI appears to be lacking a number of traditional investment protection, such as the fair and equitable treatment or the full protection security and so on. So there is in the CHI a number of elements which are interesting when you look at market access. However, when you turn your attention to investment protection, the CHI does not feature the usual provisions. Again, I want to insist on the fact that both EU and China have agreed to continue talks in this respect for the next almost 2 years, right? And also until they reach the conclusion of a further upgrade, the CHI, many BATs remain in force and regulate investment relationships between the two blocs, the two parties. Now, in the CHI, what's interesting is the question of market access, the question of transfer of technology, the question of the regulation of state-owned enterprises, and finally, the question of subsidies regulation. And I want to address each of these 4 points because they form, if I may say, the meat of the CHI. This is what the CHI has to offer. So let me start with a few ideas about market access. As many of you may know, in international trade and investments, market access is a company's ability to enter foreign markets by selling its services, its goods in another country. So just to be clear, market access is not the same as free trade because market access is normally subject to conditions or requirements such as tariffs or quotas. Whereas under ideal free trade conditions, goods and services can circulate across borders without any barriers to trade. So the logical consequence is that expanding market access is often a more achievable goal of trade negotiations than achieving free trade. Now, between China and the EU, the access has been agreed on the basis of a negative list approach, which means that all sectors are included unless expressly excluded. For example, the list of excluded sectors covers under the CHI audiovisual services, air transportation services, activities in the exercise of government authority and procurement, with a number of specifications and limitations. So there is market access. It takes the form of negative list with a number of sectors expressly excluded. What's interesting when you look at the market access commitments under the CAI is that China has made significant commitments in respect of market access for the manufacturing sector. I say it's important because the manufacturing sector makes up more than half of the total of EU investment in China. In respect of services, China has committed to providing access to EU investors in the telecommunications sector, financial services, private healthcare, and also environmental services. China has done so by lifting a number of restrictions, including things such as joint venture requirements for EU investors, or economy needs test, or other restrictions on foreign investments, and also some nationality requirements for senior management. So, in a nutshell, when looking at market access, which is a key element of the CAI outcome, the idea is that China has agreed on significant commitment when it comes to manufacturing, and that's important to EU investors. In terms of services, it's perhaps a bit less, or let's say that the commitments taken by China are more carefully crafted and subject to a number of limitations. So for the question of market access, the outcome of the CAI, I would say a balanced one. On the paper, the CAI is not a radical, a treaty that radically opened up Chinese market to EU investors and vice versa. It more looked like a treaty that crystallizes a number of positive trends that can be observed in China over the last years. And this crystallization in the CAI can only benefit a number of EU investors, whether in the manufacturing or the services industry. Now, the second element I want to discuss is the question of technology transfers. That's another very important aspect of the CAI, I think. As you surely know, developing countries in particular see transfer of technologies as part of the bargain in which they have agreed to protect intellectual property rights. So the WTO aims to achieve the transfer and dissemination of technology as part of its objectives. And the WTO, as another, as a major example, also aims at specifically requiring developed economies to provide incentives for their companies to promote the transfer of technology to least developed countries. So that's the background when we talk about transfer of technology. Now, with respect to technology transfer, I think that the CAI is important because it sets out clear rules to prevent forced technology transfers, including prohibitions on certain investment requirements, which would result in such transfers, prohibitions on direct and indirect interference in contractual freedoms of technology licensing, and also enhanced protection of IP, intellectual property, sensitive business information and trade secrets, and a few other things. So commercial operations in China, at least from the European perspective, have been plagued by concerns for the confidential information and technology. So this is, in this respect, something very important that the CAI achieves. The regulation of technology transfers by the CAI in the form of rules that prevent a number of domestic requirements is a very important point for EU businesses and EU investors. Then there is, let me combine them for the sake of time, state-owned enterprise and subsidies. There is also, between China and the EU, this issue of SOEs and subsidies. I can combine them for the sake of time, but they're also deeply intertwined, in fact. Well, there is a substantial work being done to improve SOEs in China through reorganization, restructuring, and even enhancing their internal governance standards. So China went as far as introducing mixed ownership in telecoms companies, such as China Unicom. This was done as a step towards making China Unicom more accountable and more focused on generating returns on equity, while of course retaining state control. So these efforts to make Chinese SOEs competitive while holding absolute control over the final decision-making reasserts the Chinese government's commitment to consolidating state control while at the same time allowing the market to be the ultimate resource allocator. So in other words, the government in China wants to keep a close eye on market forces while reserving the intervention option in very extreme or critical situations. Well, that being said, I think it's important to mention that China's legal and regulatory systems are going through crucial transformations with regards to investments and IP rights. But they are not yet prepared to regulate giants, significant corporations, which is why the government has chosen to retain the option of direct control over its SOEs. Besides, once the property rights are brought in terms of framework and protection to a certain level, the government could profit far more by privatizing competitive enterprises rather than selling off distressed assets in the current legal environment. So over the last 3-5 years, privatization initiatives in China have been further delayed by the threats of an intense and intensifying trade war between China and the US. In fact, it seems that China has been forced to prioritize security over efficiency, which means a rather conservative stance of increased centralization in order to facilitate an immediate response to any economic threats. That is what's gaining more traction in the past years. Now, for all these reasons, privatization of SOEs at this stage seems to be more risky rather than rewarding, considering the potential social costs of layoffs, potential defaults, and mismanagements of enterprise by new private owners, which could lead to major disruption and immediate destabilization. So For that reason, the government is wise to continue taking action to improve the efficiency of SOEs and to gradually develop a privatization framework for the future to ensure sustainable economic growth, as everyone realizes that there is a limit to how much the government can improve SOE efficiency within a centralized governing system. So, these few comments are important. This background is important to assess the KAI on SOE and subsidies, because one cannot expect too much from the KAI given the difficulties to reform SOEs in China by China. In fact, the KAI, when I look at it, is a good outcome because it is intended to level the playing field, and as such, it includes a commitment to transparency. Of course, some caution has been expressed as to the value of the KAI due to the lack of specific and enforceable investment protection provisions, and also to the fact that there is no guarantee that the EU and China will be able to agree effective provisions in this area, in this space. So what's important when we look at SOEs in the KAI is the broader context. The KAI requires that the parties ensure that their SOEs act according to commercial considerations, which means that they are required to ensure that their SOEs behave in a way that's expected of a commercial business, and that the SOEs do not discriminate against investors of the other states and covered enterprises when they purchase and sell goods and or services. Now, on subsidies, the KAI also focuses on transparency. The KAI focuses on transparency in the subsidy space by extending the current WTO, so World Trade Organization transparency requirements into the services sector, and by establishing a two-stage consultation mechanism to allow the collection of necessary information to assess the effects of specific subsidies. So you see that all in all, in particular with respect to the four big issues that are explicitly addressed and regulated by the KAI, the outcome is rather positive. It brings something to the EU-China relationship. Now, I want to come back, as promised, to this issue of dispute settlements and the KAI. In today's talk, I really want to discuss the question of dispute resolution, which requires to also address the ISDS reform in the context of the EU-China investment negotiations. So, as I briefly mentioned in my introduction, the KAI does not contain the traditional disputes mechanism of investment agreements. That's a fact. Just that is meaningful. Now, usually, an investor-state dispute settlement provision, or ISDS clause, would allow investors to seek compensation if either party breaches their commitments. Instead of that, the KAI provides for, number one, arbitration between China and the EU. So careful, it's arbitration, as I will explain a little more later, between the two parties. It does not involve the investors, so the private companies. And instead of the traditional ISDS, the KAI provides also for this 2-year period for the parties to reach a further agreement on ISDS. So a few further comments on arbitration between China and the EU. The dispute settlements mechanism has a two-step approach in the CAI. First, consultation between the parties with the goal of reaching a mutually agreed solution. That is the stage one of the state-to-state arbitration. And number two, a move to an arbitration panel procedure if no solution is agreed. So this mechanism is interesting because the mechanism also provides specific rules relating to the arbitration tribunal, including requirements for the arbitrators to be highly qualified, experienced, and independent. Also, the CAI further sets out specific rules of procedure and a code of conduct for panelists. Let me just add on that point that the CAI, of course, only applies to disputes between the two states. So it's not at all for disputes involving any investors. And that's a major shortcoming for the time being. Now, for the time being, because I move on to the second point, there is a 2-year period to agree on ISDS. In fact, investors cannot bring an arbitration directly against either EU and China under the CAI in its current form. Instead, the CAI merely states that China and the EU commit to completing their further negotiations on investment protection and investor-state dispute settlement within 2 years of the signature of the CAI. So, presumably, these future negotiations are intended to address whether investors may obtain redress for the host state's failure to provide the investor protection promised in the CAI. That should be, or that is what can be expected. So, the dispute settlement mechanism that China and the EU will choose now, thinking about the future, is important because what they will later choose as dispute settlement mechanism will shape the future of the investment relationships, while also having deep ramifications for the ISDS system as a whole. As you know, investment law, and as a consequence, public international law, is progressively being remolded by the initiatives of numerous countries. Moreover, it's also crucial to emphasize what the potential for changing the ICS represents for China itself in the broader context of international law, because China has adopted a rather defensive approach towards international adjudication for years. So the fact that China may be changing its approach on dispute resolution will also have, or may also have, a deep effect on many other countries, as they tend to follow the mechanisms, or they might be tempted to follow the mechanisms established by the EU and China in the area of international investment protection and dispute resolution. So the goal of the EU-China CAI is to reach a higher protection level between China and EU member states. As a matter of fact, the CAI displays a relatively great scope of application and regulates a large number of important issues for foreign investors. Now, in what's provided by the CAI, consultations, mediation, and arbitration can be utilized to resolve the possible disputes between the two parties, with a stipulation that the trial should be independent. Dispute resolution is really very important for many practical reasons. It's not just important as a traditional feature of all investment treaties. ISDS, or to be more precise, investment dispute resolution is a big issue between EU and China, also because the most frequent users of the ISDS systems are investors from the EU member states. They have also supported the merits of ISDS for decades. As I said a little earlier, EU member states have signed hundreds of bilateral investment treaties. But here I focus on the fact that a large number of investment disputes in the world were initiated by EU investors. So it means that the probability of sovereign measures being challenged by EU-based investors is higher than challenges from investors outside of the EU. I think that if we, I don't have the statistics here, but if we take a look at some statistics produced by the UNCTAD, we'll see that in between roughly the early 90s to 2019, 2020, Spain and Canada were frequently respondent in ISDS proceedings. And as for the most active claimants, there were many cases filed by EU investors coming from Netherlands, United Kingdom, France, and Germany. So really, EU member states, and more precisely EU investors, have been massively using ISDS. And that's something that needs to be taken into account by China in the future negotiations, because there is a risk of being sued in the future looking at this pattern. So that's for the EU side. Now, what about China and its approach toward dispute settlements in the field of investment, and more generally in the field of international law? Well, as a brief summary, I would say here that China used to be a quiet player in international rulemaking until roughly 15 years ago. So the CAI negotiation process might indicate that China supports improving ISDS, although only if it's subject to the oversights of a type of appellate body. Now, on top of that, as there is a risk that a semi or permanent neutral international forum like the ICS would facilitate foreign investors' claims against it, China may not be interested in the establishment of such a forum. So the idea is that the CAI as such has to be very carefully assessed in light of both EU and China practices in terms of dispute resolution and interest. And here things are very complex because the continued development of international courts and tribunals depends greatly on China's approach. That's going to be up to China to agree or object to the ICS promoted by the EU. So the influence of the prospective EU-China CAI, the second stage of the negotiation, to be clearer, will be very important because it will show the two parties and the world what they can agree on in terms of dispute resolution. It will be important because the EU-China CAI will show everyone what can be reached as a balance between the private interest that foreign investors want to enjoy, and on the other side, the host state's ability to protect their public interest through the regulation of FDI. A last word on that comes to my mind is that, of course, the EU already has the ICS with Canada and Vietnam. But in the meantime, that means since the treaties with Canada and Vietnam were concluded, the UN CITRAL has made significant progress in its technical discussion on the reform and the reshaping of investment dispute resolution. And it means that both the EU and UN CITRAL are perhaps converging in one direction, which is to replace ISDS with a type of international permanent courts for the settlement of investment disputes. Perhaps the next step or steps will be China promoting the dispute resolution regimes regulated in the CAI. And as a new architect, China can achieve its independent role in the international legal order. Also, with the establishment of the Belt and Road Initiative, more disputes might occur between EU and China. And so the impact of dispute settlement mechanism in CAI on EU-China investment relations really calls for further technical work, research, and observations. That is, in any case, an aspect of the EU-China relationships that will remain very important for the years to come. Because it's only with a more efficient dispute resolution regime that the benefits of the EU-China CAI can be balanced and will be balanced. So looking at the CAI, what I discussed in terms of history, key structure, substantive contents, and the absence of dispute resolution for now, I believe that the CAI is essential for three key reasons. Number one, the CAI is very important because it crystallizes the position of investment treaty relations between China and EU member states. Both China and the EU are global leaders in the negotiation and conclusion of investment treaties with BATs or FTAs. China is the world's most active BAT making state, and with many of them with EU states. On the other side, EU member states have collectively entered into nearly half of existing bilateral investment treaties. So China and EU, or EU member states to be more precise, are big BAT players. Now, as a general matter, BATs display a certain consistency from treaty to treaty, although state treaty-making practice has evolved over the past decade. For that reason, when you look at China's BAT practice, for example, there is a considerable variation of rights and obligations when you look at different period of time. And so in order to ascertain the value of the CAI, it's necessary to analyze this portfolio of all treaties that had been concluded earlier by either China and or the EU member states. And the basic idea, the key idea here is that the CAI has many provisions which represent a significant departure from past treaty practices. And that's meaningful because it shows China's willingness to approach foreign investments in a more liberal way than ever before. So today I don't have the time to look at the details, although I welcome any questions that you may have, but I think that's a very important idea to keep in mind, especially as too many experts have been critical on the CAI. I think many underestimate the meaning of the CAI in light of past treaty practices. There may not be everything in the CAI, but the bit that's already in shows a great change compared to earlier treaties. And that is, in my view, very important. The second point is that despite being a major innovation, the CAI does not address some issues. That's fine. Why? Because investment treaties can differ in their particulars, but as a general purpose, they always function, or they always serve a function of liberalizing investment flows between states. And so, in addition, investment treaties can seek to address many more issues than the mere regulation of FDI. So that's a fact that increasingly investment treaties signed elsewhere in the world and by some other parties increasingly seek to strike a good balance between investor protection and the right of states to regulate. That's what you can observe in the CPTPP, the RCEP, and a number of other recent BITs. So the CAI is a bit frustrating because it does not yet address fair and equitable treatments, full protection security. But at the same time, the CAI is interesting because it regulates certain aspects of sustainable investments, environment, and labor standards. And that's something which otherwise does not exist in previous EU member state China BITs. So there is here something important. The third point is that the CAI is an attempt to reconcile bilateralism and multilateralism when you look at how the rules of the international economic regime are designed over the last years. So here's an observation which is just a bit more academic, a bit more conceptual, but the basic idea is that we see that the international economic regime has entered a new phase of perhaps a reassertion of sovereignty by states. And so the idea is that while states continue to show respect for the values of international law, there is an increased reliance on unilateral mechanism to protect a number of interests. So there is a new form of unilateral economic law that is emerging, that is gaining importance in the developments of investment and trade law. And that's important because when you look at what's happening between EU and China, even in the field of investments, it's not limited to the CAI. There are in China and in the EU a number of domestic measures, so unilateral measures that have been recently taken or that are in the making that are all about investment. So I think here about screening mechanisms in the EU, in China. I think about the EU attempt to regulate foreign subsidies, many other elements that may even include sanctions of different types. All these elements are, in a sense, unilateral, and they have the purpose to regulate foreign investments. So the CAI got to be understood in this broader context. There is, as a matter of fact, an increased reliance of states on domestic measures. And so the CAI is probably, at this point of time, at this juncture, just a reflection of these tensions which already exist between international law in the form of traditional trade and investment treaties, and this appetite of many states to act unilaterally. In fact, the modest, what some see as a modest outcome of the CAI can be balanced with this idea that perhaps we should also be looking at what has been and what is being decided at the domestic level in order to better assess the CAI, and in any case, before to conclude that the CAI is not the major treaty. I come to my conclusion. I try to keep an eye on the time. I will just need 10 minutes, not more, 5 minutes for that conclusion, and I'll be happy to take your questions. I already see many of the questions in the chat box. But let me try to summarize my thought and identify the key takeaways. So in conclusion, I think that despite the fact that the CAI has been met in some quarters with skepticism on economic and, say, geopolitical grounds, it's possible to have a different assessment. And my assessment, which focuses on the law and on the long-term implications, is different. It's true that the CAI provides only modest new market access in China for EU investors, but this is because China has already made progress in recent years in liberalizing its foreign investment regulations unilaterally. So what the CAI does is modest, but interesting. What the CAI does is to bind this unilateral progress under an international treaty, so making an improvement for the EU firms insofar as their market access rights can be and should be effectively enforced. Legally speaking, commitments made under a treaty have a greater value than commitments only made unilaterally, because what can be made unilaterally can be unmade at any time. Most important, as I mentioned, the CAI includes new rules on subsidies, state-owned enterprises, technology transfer, and transparency, which will improve effective market access for EU firms operating in China. And that's a positive point of the CAI. So these bilateral new rules could also pave the way for reform of the multilateral rules under the WTO, with the aim of better integrating China into the global trading and investment system, which is a goal, by the way, shared by the EU, the US, and a number of other like-minded countries. So my last word on that will simply be that from a legal perspective, that pay attention to existing BITs, that pay attention to the policies and law in China and in the EU, the CAI is an important agreement. It's an agreement that is worth having for both EU and Chinese investors. I will close by simply reminding you that, of course, there is some ongoing negotiations, and so that the CAI could be further upgraded. And we could have, in the coming 2 years, some further upgrades, provisions, commitments, that would even make the CAI even more important for the two parties and for the rest of the world. I tried to cover as many things as I could, but of course you understand that we cannot go always in too many details. So I'm glad to now open the floor to your questions and comments, which I'll try to answer.
Thank you so much, Professor Chaisse. Thank you for your very excellent and really brilliant, insightful observation to the CAI. I observed that already many questions, several questions written in the chat room. So I invite the attendant who have written their question in the chat room to raise your hand and ask your question briefly to Professor Chaisse because of the time constraint. Thank you. Firstly, I invite Apolline Boreuil. Are you there?
Or perhaps I can quickly read the
Yeah.
questions, no problem on my side. That will help me to think at the same time.
Yeah.
So I think the first question, there are two questions. The first question, straightforward and difficult. When do I expect the CAI to enter into force? It's a good question. Happy to clarify that. The second question, don't you think that the lack of transparency and unfair competition of Chinese subsidies is not adequately addressed by the CAI? Isn't that a major weakness of the treaty? Okay, it's a good set of questions. On the entry into force. Here, I think we need to think both in terms of law and politics. Ratifications are always a difficult process, and there are many issues that could be discussed. But in my reflection, I would say that first, I think there are many benefits in the CAI for both China and the EU. All right, as we discussed, as I tried to explain today, improved market access for European firms in China, better rules on subsidies, SOEs, transfer of technology, which are acceptable for China, that helps to pacify a number of trade relationships. All this is good. I want to stress this first point to say, despite many problems that will emerge, I have little doubt that both EU and China have a political and economic interest in getting the CAI into force. All right, so that's going to happen. When? Well, I cannot tell you when exactly the CAI will be ratified, but for sure it will not happen until 2023 at the earliest. I don't think it can happen before late 2023. There are two series of reasons, and they're essentially political for that. So everybody understands that the CAI is good, but in Europe, there's a number of potential changes very soon. In Germany, there are the federal elections that will take place in, if I'm correct, September 2021, so after the summer. In France, there'll be a new presidential election in May 2022, in less than 1 year. So that's important because, in short, the German and French elections will have to take place to have a new leadership in these two countries and in the EU. And it's only then that the big question of the ratification of this treaty can come back and can be pushed, supported by the EU itself. For now, it's not the right time. I also note, and many of you will know more than me about that, that on the Chinese side, Chairman Xi will have to secure his third term as General Secretary of the party. And if I'm correct, that will be somewhere in the fall 2022. So given the little tensions that we can observe these days between the EU and China, right now is not the right time for the two blocs to launch the ratification. And it's not the right time for the political leaders to make any compromise. All of them have to wait a bit before I think they go back to the political negotiations and get something agreed later on. So for all these reasons, I would expect the CAI to get back on track in the winter 2022-23. And by this, I only refer to the question of the ratification, and so the entry into force. I'm not talking about the ongoing negotiations, which are more technical and they are likely to continue in the dark without having to be commented in the press. But as far as the entry into force is concerned, I think that if you follow what's happening in the EU and China, we might get a better sense of when ratification will be done in early 2023. So I'm not telling you that the CAI will enter into force in early 2023. What I'm saying, I hope I won't disappoint anyone, is that we will only know when the CAI may enter into force in early 2023. And so we are more talking about an entry into force in 2024, 2025. The second question is a little trickier, although very interesting. It's about the lack of transparency and unfair competition. So, the lack of transparency and unfair competition, as you said, of Chinese subsidies is another EU concern that the CAI addresses, all right? As I explained, I think the CAI goes beyond WTO rules because it also includes transparency obligations for subsidies in the service sectors. So both EU and China will be required to publish, I think, promptly. That means within the calendar year after a subsidy is granted, all the details of the subsidies covered by the agreement. So they will have to, both EU and China will have to communicate on the subsidies and say what are their objectives, their form, the budget size, who is the recipient, and many other things. So that's important. The CAI also obliges both parties to engage in consultations to share information, additional information on subsidies that could negatively affect investment interest. And in this respect, it's important to note that the requesting party may ask for additional information about the subsidy, so the amount, for instance. So careful, there'll be under the CAI a number of significant obligations that add quite a lot in terms of subsidies. That being said, you are right. I mean, I sense that's implicit in your question. It's true that a party cannot be forced to remove such a subsidy. So if you were, taking a hard line, you could then criticize the CAI and say, well, the CAI is weak on this kind of question, because what you only find in the CAI is that the party is only obliged to use its best endeavors to find a solution. So in a nutshell, and I take the next question, the CAI is good because it can improve subsidy transparency. However, true, there is a limitation to this, which is that the CAI does not create new disciplines on prohibited subsidies. I just want to invite you to think about that. It may well be because there was no political momentum to agree on such disciplines. And so it's a bit meaningless to hope for more. I see another question. As you just mentioned, China and the EU initially agreed on a negative list approach with respect to market access. However, the final CAI in principle seems to adopt a positive list approach regarding the market access commitments made by the EU and China in Annex 3, which provides in its, the question is very long. Could I know which approach does the CAI adopt regarding the market access commitments? And the question is with respect to the compatibility between the positive approach and the negative list approach adopted in China. The other question is CAI in principle has a MFN clause. However, it also provides that the treatment referred to in the MFN does not include the substantive provisions and dispute settlement procedure contained in third-party treaties. what's the purpose of having the MFN clause in the agreement? So perhaps I can start with the second question, which is very important because MFN is always a key provision. So MFN is always important, but it's increasingly subject to limitations. Okay, this is what we observe in many investment treaties. There is a number of carve-outs in recent MFN clauses in multiple treaties. In this respect, the CAI is not very surprising. As many other treaties, the MFN is subject to a limitation, which is that it cannot apply to a dispute resolution. So I agree with this statement. What's the purpose of such MFN? I think there are 2 points here. The first is that the current version of the CAI is just the first step in the relationship between the EU and China. So you can think about this CAI MFN effect, application and effect, and now conclude that the implications are not significant or much less significant than many other old MFN clauses found in some other investment treaties. That's true. But as I mentioned earlier, negotiations will continue. And so you can very easily think that perhaps in 2 or 3 years, EU and China will come back with an upgraded CAI that may feature more substantive investment standards to which that MFN will apply. So here we have to be careful because if the CAI is upgraded and you add a number of substantive provisions, it may also mean that the MFN can be amended. So we already speak about a number of potentialities here. But that's my first point. The fact that there would be a relatively substantive MFN or interesting MFN provision in the CAI, although there is no substantive rights or not so many substantive rights, doesn't mean that the MFN clause is absurd or useless. It may depend. The second point is with dispute settlement. I think that here it was strategically important to limit the scope of the MFN for many reasons. First, China has signed many BITs, and any of these BITs could have provided to EU investors a greater protection. And so the risk with a broad MFN would have been to perhaps trigger some complex claims against China. The same is true also vis-a-vis the EU, which is trying to renovate and to upgrade its arm or its member states BIT program. So all in all, the idea is that the CAI MFN is not a very impressive provision, but I would add for now, because we can still see an upgrade very soon. And second, I would say that the CAI MFN quite resemble to many other recent investment treaty MFN clauses. If you look at the RCEP MFN is also not very impressive because it does not apply to dispute resolution and third-party treaties. So here, I would not draw too many lessons when it comes to MFN. I would simply highlight the need to look at the next steps in the negotiations. Just one last point, which I'm thinking about. It's also important when we look at the CAI to compare with more recent EU investment treaties, FTAs with investment chapter. And I think that in the EU-Vietnam, the EU-Canada, and the EU-Singapore, you also find MFN clauses which are very carefully crafted and subject to a number of limitations. So the CAI here just reflects, what we find in a number of other treaties. Now back to the other question of market access. So I think the key idea is that there is a convergence between what China has been willing and able to achieve at a domestic level and unilaterally. That's something I would maintain. The CAI simply codifies in a treaty the market access that China is otherwise, or that was otherwise willing to do. The CAI is not in itself something that adds to recent efforts on the Chinese side. So some have seen that as a limitations. But as I told you, I don't think, and I think that the CAI cannot be assessed in a vacuum. In order to deal with the trade distortive effects in the EU market, which are caused by subsidies granted by third countries, but in fact, it's essentially China that is targeted. The Commission has also taken a number of initiatives recently. And there was, in May 2021, so just last month, a proposal for foreign subsidies instrument, alongside also a new industrial strategy. So these developments are important because these instruments aims to close I would say the regulatory gap in the single market, as European Union competition rules do not cover foreign subsidies that provide an unfair advantage when acquiring EU companies or engaging in other commercial activities in the EU. So the basic idea is that here, when you look at market access plus a number of side issues, the CAI is complemented by a number of actual or potential, meaning that are yet to come, but that are in the pipe, actual or potential unilateral measures at EU level. And this is something which is important because it will allow the EU to monitor the implementation of the CAI on the Chinese side, for which I don't anticipate major compatibility issues on the Chinese side.
Okay, thank you. Thank you so much, Professor Chaisse. Due to the time constraint, I would like to abuse my privilege as the chairman of this conference. One of the attendants asked a logistic question. Would you permit to share the video of the conference for a scholarship purpose, but not for commercial purpose? Because some attendants want to use your video to make further inquiries, etc., etc. Do you?
Of course, Ben. I'm happy to have the video circulated, made public, and also the PowerPoint, which I'm happy to send you in due course.
Thank you. So I will conclude that your presentation prompted many reflections and many questions. I think I share the feeling that we don't have enough time to discuss in detail, but we do hope that we could find a moment and find the opportunity to go more details into the CAI. So let me thank you again and keep contact, and especially we are very grateful for your contribution to this networking, not only for the EUPLANT, but also for the network for which you are the president. You are the, just moment I see in the PPT, you are also the president network for FDI. So I hope we could keep in contact for further research purpose and to more exchange and all cooperations. Thank you so much. And also, I will thank all the attendants to this video conference. Thank you so much. And see you and enjoy the start of the day.
Bye-bye.
Bye-bye. Bye-bye.